we have a continuation of a public hearing for Santini residents, 222 Mount Zion Road. Appeal of interpretation 155-41.1. We had asked the applicant a few questions at the last meeting, and they have provided answers to those questions, which Andrew will read first.
All right, the following letters from Control Point Associates, Inc., PC, December 29, 2025, regarding the Santini residence, single-family residential development, tax ID 102.3-2-15.300, response to ZBA comments. Dear Chairman Khan and members of the Zoning Board of Appeals, as you may recall, we represent the owner of the parcel located at 229 Mount Zion Road in the town of Marlborough, comprising approximately 18.69 acres within the Rural Agricultural RAG1 zoning district. During the November 13th, 2025 Town of Marlborough Zoning Board of Appeals meeting, the board had requested the following information regarding the project site compared to the town of Marlborough ridgeline. Number one, what is the length in miles of the entire Marlborough ridgeline from north to south? Response, the length in miles of the entire town of Marlborough ridgeline is 6 plus or minus miles. See attached Exhibit A depicting these dimensions. Question 2, what is the distance from the proposed house location to the 1,100-foot ridge to the north? Response, the distance from the proposed house location to the taller ridge to the north is approximately 0.8 plus or minus a mile, or 4,300 plus or minus linear feet. Question 3, what was the virgin elevation of the proposed house location prior to clearing the trees from the home site? The elevation is currently 1,007.5 feet. Response as shown on Exhibit H, slope conditions map, dated September 13th, 2024, of the KARC submission, dated August 28th, 2025, the spot elevations depicted on the map reflect virgin elevations of the site. Thank you, Patty Brooks.
Thank you. Is there any other comments that we haven't heard at the last several public hearings that you would like to put on record?
I will.
Please state your name and address for the record.
Thank you. Patricia Hathaway, Town Marlborough, would you like me to spell it? Yeah. H-A-I-D as in David, A-O-U-I. Thank you.
Patricia, if we, for the sake of everyone who wants to speak, if we keep all the comments to 3 minutes.
Yeah.
Great. Thank you. Thank you.
Good evening. I just wanted to take this moment to remind everyone that the matter before this board should be decided based on the merits of the application and not the merits of the applicant. For far too long, we've heard that it's who you know or who you're related to that really matters in Marlborough, not the rules or the laws. The town, however, has a legal responsibility to treat all applicants the same, not showing favor to any applicant because of how long they've lived here, how nice they are, their involvement in any particular activity or another. In fact, asking this board to base their decision on any positive attributes of the applicant is also asking this board to act in a prejudicial and illegal manner. I'm advocating that this board simply follow existing code and town laws as they assess the merits of the appeal and make their decision accordingly. Furthermore, if this board is prepared to grant this appeal, then they must stand ready to grant all further appeals for development above the ridgeline. To do otherwise would not only be unfair, it may also open the town up to even more legal action and cost the taxpayers even more money. Thank you for your time this evening.
Thank you. Anyone else? Yes, ma'am.
Good evening. At a previous meeting, the applicant's sorry, Mary Ellen Glory, Marlboro resident. Glori. Sorry. At a previous meeting, the applicant's representative submitted that there is no other buildable location on the applicant's lot. We still don't know if the representative of the town has determined this claim to be true or false. Would you like to address that question tonight? No, okay. So I didn't realize until I reviewed the October meeting minutes that the applicant's representative has essentially suggested that all home construction proposed below the one absolute highest point on the ridgeline should be approved. This suggestion is really reaching because it would be absurd to think that we're affording the ridgeline any protection at all if every application is to be judged by a single point of elevation that may be several miles away from a location in question. After all, the ridgeline, I hope we can all agree, is indeed a line. Any line is made up of many points, but it is not a single point. For some final clarity, I'd like to share two diagrams with you if you'd pass those down. Both of which show what a small portion of the Marlboro ridgeline might look like as viewed from the east. They also include an excerpt from the Ridgeline Protection Law, specifically Part F, Paragraph 4. The text at the top was edited to exclude a lot of blah blah, but at the bottom is the full text of that section. The highest elevation of the ridgeline is emphasized in red. On the first diagram, the homes would be permitted, assuming they comply with the other requirements of the law, because they do not extend above the highest elevation of the ridgeline as viewed from the east. On the second diagram, the homes would not be permitted because they extend above the highest elevation of the ridgeline as viewed from the east. In my humble opinion, this is and has always been the intention of the law, and any interpretation that promotes applications, determinations be made based on one single point of ridgeline elevation is grasping at straws. So that's all I have to say about that, but I would like to add something based on what was mentioned at one of the last meetings about posting minutes. So I recently had a conversation with someone about how it's difficult to keep up to date with what's covered at these meetings when minutes aren't posted on the town's website until after the following month's meeting when the previous month's minutes are approved. And I learned from that person, unbeknownst to me and perhaps to you, that New York State's Open Meetings Law, Article 7, Section 106, on 106 on the second page, number 3 states in part, minutes of meetings of all public bodies shall be available to the public in accordance with the provisions of the Freedom of Information Law within 2 weeks from the date of such meetings. News to me.
Time.
Can I just finish?
Yes.
Additionally, in private correspondence with a friend, the New York State Department of State Committee on Open Government said, and I'm paraphrasing, that although as a matter of practice or policy, many public bodies approve minutes of their meetings, there's nothing in any law that they're aware of that requires minutes be approved. Further, they said that minutes prepared and made available within 2 weeks may be marked unapproved or draft, so that the public can generally know what transpired at a meeting and at the same time be notified that the minutes are subject to change. I submit this information for your consideration and hopefully adoption into your best practices or standard operating procedures. But please don't shoot the messenger. Thank you for the opportunity to speak and for your attention this evening.
Thank you. Anyone else? Yes, ma'am.
It's the princess.
Hi, I'm Cindy Lanzetta, and I'm a resident of Marlboro, and I am not here speaking on behalf of the planning board in any way. I'm here as a resident and a concerned citizen. And I did go to look for the minutes of the last meeting, which I guess will be up after you approve them. So the only ones that were available to me were November's meeting minutes. And I was looking at the response from the applicant's consultants to the requests from the zoning board. And I noticed that discussion, which I also noted with the applicant's consultant. You were talking about the grading and clearing of the property. And I have noted that the consultant said that they had not received any violations. I did submit earlier on that that wasn't true, that there had been multiple violations to the extent that the town's lawyers actually sent us a violation cease and desist order. So there were violations for grading and clearing, so that area has been significantly changed over the last few years. And this was after the fact that the applicant was told that he could not do any of this work without a permit. So anyway, looking at November's minutes, I noticed that the zoning board had talked about the difference in the topography and had requested that a topographic map be prepared that included the changes between the original site and what has been done up to date. There was some discussion about that would be difficult, but the consultant said that they would submit that for your information, and that was not part of what was included here. What I do see is the surveyor, who is using a map that is recently dated, saying that the map reflects virgin elevations on the site, but I don't know how that's possible if this is a map that's just recent and doesn't date back to the original maps that were done. Besides the fact that, you know, engineering consultants can look at, there's plenty of photographic information from the past. Even Ulster County Parcel Viewer has pictures of that site that go back to 2020 and even farther back than that. So I really think that the consultants should give you the information that you requested. Thank you.
Anyone else? Comments from the applicant?
If you were pointing behind me or at us?
No, ma'am, I'm
Okay.
pointing you.
Thank you, Mr. Chairman. If you recall, I'm Kelly Leibert with KARC Planning Consultants.
I'm sorry, one second, I just have to share this, my battery's dying. Okay, so you must
Sure.
start.
I'm Kelly Leibert with KARC Planning Consultants representing the applicant. Mr. Neshwa is going to do a brief summary. He's the attorney for the applicant, and he's going to do just a brief summary of the application, just a concise overview. None of the information that he's providing is new, so this is just a final overview of the project.
Good evening, members of the board. I'd like to start off by congratulating Mr. McKeel on your retirement, and best of luck. As Ms. Leibert stated, my name is Michael Neshwa. I'm the attorney for Stephen Santini with respect to the Santini Residence Project at 229 Mount Zion Road. I'm going to start off by agreeing with one of the members of the public, Ms. Hayview. I do agree that we should be considering the application on the merits, and that's sort of the entire purpose of our application. Now, there have been several public hearings regarding this application, and many members of the public have expressed their thoughts, concerns, personal opinions even. But I think it's important to remind everyone what the purpose of the hearing is as it relates to the Santini residence. And I say this because when we review the minutes of the prior meetings, there appears to be some confusion as to what is and what is not relevant to this appeal. And I want to make sure it's clear what we're doing here. Now, the town building inspector, Thomas Corcoran, denied Mr. Santini's application for a single-family construction based on one reason only that was elicited in the town engineer's June 10th, 2025 letter. And that reason is, quote, The potential site identified on the plans is not in compliance with the applicable portions of the Town Code, section 155-41.1. Now, the building inspector's August 12, 2025 letter cites only to section 155-41.1, subsection F4 of the Town Code as the basis of the denial. And that provision of the Town Code reads, applicants for construction on properties to which this section applies shall demonstrate to the town engineer and the town code enforcement officer that no proposed building or structure, parentheses, inclusive of chimneys, vents, or other fixtures attached to the structure, close parentheses, subject to this section, shall extend above the highest elevation of the Marlborough Ridge line as viewed from the east, as determined by the town engineer and the town code enforcement officer. Now, referring back to the building inspector's August 12th letter, he references the town engineer's June 10th letter. Looking at the town engineer June 10th letter, the only provision that he cites under subsection F states as follows. The information submitted, including topographic information from the Control Point Associates map referenced above, identifies that a proposed house location is at elevation 1000.7.5. The highest point on the property identified by spot elevation is 1012.8. This locates the elevation at the proposed house 5.3 feet below the highest point on the subject property. Carp Planning Consultants letter states that a building height is proposed at 27 feet. Now, the purpose of this hearing is to determine where the height is measured, where it's taken from. The town has interpreted the code to mean that the measurement is taken from the highest point of the property. Our interpretation, based on the clear and unequivocal language of the code as amended in August 2024, means that the measurement is to be taken from the highest point of the ridge line, singular, not the property. Now, Mr. Nicola stated on the record earlier the responses to the questions that the ZBA asked at the November 13th meeting. And while we did provide those responses, I respectfully claim that these answers and questions are relevant to the purpose of this application. Now, Mr. Santini's appeal of the code application focuses only on 155-41.1, subsection F4. Specifically, does Mr. Santini's proposed structure, quote, extend above the highest elevation of the Marlborough Ridge line as viewed from the east as determined by the town engineer and the town code enforcement officer? That's the appeal. What this appeal does not concern is the disturbance of tree lines, tree clearings, location of the proposed driveway, grading, work done without a permit, unrelated proposed residential or commercial projects, nor does it concern personal opinions. Several comments from the last few hearings have focused on those very concerns, but none of them were mentioned in the building inspector's rejection letter from August 2025. The only basis for the denial of the Santini project under the building inspector's letter is solely under the interpretation of Town Code section 155-41.1, subsection F4. Now, before the board, you have a red line of the Town Code prior to its amendment. And I think it's important to understand how the code was amended, what was stricken, what was added. Because with every strike and every addition, there is a specific intent. August 26, 2024 was when the Town Code was amended. Prior to the amendment, the code read, applicants for construction on properties to which this section applies shall demonstrate to the reviewing board or town engineer, as the case may be, that the proposed building or structure will not extend above the predominant tree line. No structure that is the subject of this section shall be located closer than 50 feet in elevation to the ridge line affected by the application as determined by the town engineer. Now, the amendment of that provision makes clear what was stricken, what was added. The prior provision specified that the height was to be taken from the property, from the predominant tree line. The revision, which struck that language and specifically included that it shall not extend above the highest elevation, singular, of the Marlborough Ridge line. That's the issue that we have before the board today. Now, referencing the project, we know that the residence base elevation is 1,007.5 feet. We know that the building height is proposed at 27 feet. which brings the maximum elevation to 1,034.5 feet. We also know that the highest point of the ridgeline is 1,100 feet. That brings the proposed residence 65.5 feet below the highest point of the ridgeline. I know there have been some concerns about the interpretation of the zoning code and whether or not there is any sort of ambiguity, but the law is clear. Any zoning code ambiguity must be construed in favor of the property owner, in favor of the applicant, and against the municipality seeking to enforce that code. And to the extent that the August 2024 revision of the code is ambiguous, it must be construed in Mr. Santini's favor. And just to recite a few excerpts from case law, a zoning ordinance must be strictly construed in favor of the property owner and against the municipality which adopted and seeks to enforce it. Zoning ordinances are in derogation of the common law and thus must be strictly construed in favor of the owner whose land is being regulated. Any ambiguities in a zoning ordinance must be resolved in favor of the property owner. Since zoning restrictions are in derogation of the common law, they are strictly construed against the regulating municipality. Now we have a letter from Day Soka Engineering from January 28, 2025, where engineer Mark Day provided his expert analysis after reviewing the Santini project to determine where the most suitable location on the property is for a single-family residence. Mr. Day's findings are as follows. Of the 18.69 acres at 229 Mount Zion Road, only 6.45 of those acres have a slope between 0 and 15%. There is a large federal wetland in the flat area on the east side of the lot. The control of surface water is a concern for residents constructed near Mount Zion Road towards the entrance of 229 Mount Zion. Mr. Corcoran's September 20th, 2023 letter admits that the proposed location for the residence is, quote, an acceptable area for a new home construction. And the only suitable location for residence construction is on the west side of the lot where the proposed house has been shown. Those are the findings of a professional engineer. Now, the town inspector and town engineer have taken the position that Town Code Section 155-41.1 subsection F4 does not permit the proposed location of the Santini structure. However, engineer Mark Day has concluded that that particular location is the only viable location for the home. Now, under these circumstances, if we were to enforce the code as interpreted by the town, not only would that deprive the property of any reasonable use, deprive Mr. Santini of the economic viability of his property, but it would also constitute an unconstitutional regulatory taking. And the law is clear on what the taking is. A zoning law affects a regulatory taking if either, 1, the ordinance does not substantially advance legitimate state interests, or 2, the ordinance denies an owner economically viable use of his land. While we have no comment on the first prong of that statement, it is certainly true that if we were to enforce the code as interpreted by the town, that Mr. Santini would absolutely be denied the economic value of his land. Now, the town code does also include a provision that speaks on the inspector's provision. The inspector determined that the proposed location of the Santini structure does not comply with the town code. However, subsection 155-41.1, subsection F4A states, if, in the town engineer's opinion, such requirements would render an existing lot unbuildable, the town engineer may recommend the issuance of, and the building department may issue, a construction permit for an existing lot of record which does not meet the requirements of this section upon his determination that no suitable conforming location is available. We have provided the engineer's report of Mark Day that there is no other suitable location for the Santini residence other than where it is proposed currently. Now, the town is not, we don't believe the town has implemented this amendment to constitute a taking. Prior to the amendment, the town has actually issued at least 11 permits on the ridgeline for single-family construction. Some of those permits are, well, actually, I would like to say about at least 5 of those permits are on Mount Zion Road. 360 Mount Zion Road, 198 Mount Zion Road, 192 Mount Zion Road, 200 Mount Zion Road, 180 Mount Zion Road. While these permits were issued prior to the amendment, the prior version of the town code was more restrictive in where the measurement was taken, to be taken from the property, whereas the amendment, after August 26, 2024, makes clear that the measurement is to be taken from the highest elevation, singular, of the ridge line. Permits were granted prior to the amendment. Mr. Santini's permit should be granted now. Now, Mr. Santini is following the town code. This addresses the case of having to look at the application on the merits rather than the individual. And that's exactly what we're doing here. The code was amended to take the measurement from, and I quote, the highest elevation, singular, of the Marlboro ridgeline. I understand Ms. Glory came up and mentioned that there are several points to the ridgeline, but that's not what the provision states. That's not what the code states. The code states in the singular, it is to be taken from the highest elevation, not elevations. Mr. Santini has demonstrated that his proposed structure would be 1,034.5 feet, which is 65.5 feet below the highest point, the highest elevation of the ridgeline. I just want to remind the public, the board, everyone, respectfully, that this appeal focuses only on that interpretation. It has nothing to do with tree lines, grading, work without a permit, other structures. That's all completely irrelevant. What's relevant here is where is the measurement to be taken from. The code as amended makes clear that it is taken from the highest elevation of the Marlboro ridgeline. We have demonstrated that the proposed structure is well below the highest elevation of the proposed ridgeline. So we respectfully ask that the board consider the application on the merits, reviewing the code as written, construe any ambiguities in favor of Mr. Santini as required by law, and grant the application. And we also respectfully request that the public hearing be closed after tonight, as there is no new information provided. Thank you.
Thank you. Anyone else like to say?
I gotta say something.
Go ahead, Mr.
I don't like speaking these events, but I gotta say something. Doug Glory, GLORID, 182 Reservoir Road. The law, in the last rendition of the code, we all come down to this. The key word is as viewed from the east. This gentleman is saying Santini application is at 1,007 feet. He's looking to the north and finds an elevation on the ridgeline 20 miles north of the application, and it's below the requirements. The whole thing is that we're missing the law, if I'm wrong, correct me, but it says that the application, the site needs to be as viewed from the east, not from the south. That's one point I want to make.
Okay, thank you. Anyone else? Ask for a motion to close the public hearing.
Make a motion to close the public hearing.
I'll second that. All in favor?
Yes.
Yes.
Lenny, can I?
Yes, ma'am. appreciate everybody for their time in the last meetings. This one was difficult for all of us. There was many discussions. I have a few comments from the chair. I have a resolution which I asked the special counsel to draft, which I would like to ask for a motion on later. Members received a copy of the draft late last night, and copies were made available to everyone after the meeting. ZBA members will have the opportunity to speak during the discussion if they so wish after the motion has been introduced. Before I do that, I would like to say a few things. This appeal is not a request for a variance where the ZBA would balance several factors to weigh the benefit to the applicant against the detriment to the health, safety, and welfare of the neighborhood or community by such a grant. Instead, it is the challenge of a denial of a building permit based on the interpretation of the zoning law. The ZBA's role when interpreting zoning law, both according to the town zoning law and New York town law, is to put itself in the place of the code enforcement officer and make the interpretation of determination that it believes should have been made. It is not the ZBA's role to determine the merits of the law. Therefore, there may be ZBA members who do not agree with the law or would not have voted for it if they were on the town board, while there may be others who would have voted for it, but that is not relevant to the ZBA's job. Furthermore, some members of the ZBA have expressed concerns and asked during public hearings about what we viewed on the site as far as work that has already taken place at the site and whether that is in compliance with the zoning law. This also is not relevant to our decision either. The ZBA's role is to review the zoning law and all of the facts, comments, and arguments put before it, and render its own interpretation of the law and determination as to the appeal. That is what we have done in this case. Conclusion, the Zoning Board of Appeals finds that interpreting the highest elevation of the Marlboro Ridgeline as viewed from the east in reference to the highest peak across the entire 6 plus or minus miles of the ridgeline, as suggested by the applicant, would contradict the legislative purpose, undermine ridgeline protection, nullify the siting visibility provisions, and lead to unreasonable and unintended results. Accordingly, the Zoning Board of Appeals interprets the highest elevation of the Marlboro Ridgeline as viewed from the east, section 155-41.1, paragraph F4, to mean the highest elevation of the mapped ridgeline segment located within the boundaries of the parcel on which an applicant seeks to construct a structure, as shown on the town's official ridgeline map, example C. It does not refer to the highest point of the entire Marlboro Ridge system. This interpretation is consistent with the statutory definition of ridgeline, harmonizes all provisions of section 155-41.1, reflects the legislative intent, and avoids interpretations that would undermine 155-41.1, while still allowing for reasonable development of parcels located in the ridgeline protection area. Based on this interpretation, the Zoning Board of Appeals determines that the proposed structure at 229 Mount Zion Road must be evaluated against the highest point of ridgeline elevation with the boundaries of the applicant's property. Under this standard, the proposed structure would extend above the highest elevation of the Marlboro Ridgeline within the boundaries of the property and does not comply with 155-41.1. 155-41.1 F4, yes. I would ask for a motion on my resolution.
Make a motion on the resolution.
Someone second? Second. All in favor? Yes.
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 Gentlemen, before you have your discussion, as I was sitting here, I realized I know you got the final copy, you got a copy of this morning, and a final copy tonight. There's several places where it refers to subdivision F rather than F4. So I've given the chairman a handwritten copy that will replace at point 1, point 11, point 12, point 14, point 15, point 18. We'll say, instead of saying 155-41.1F, we'll say point 4. And, same thing on the middle of page 4, the top of page 5. Those changes. Then on page 8, the paragraph that says according to the zoning board. So the way the chairman read it is actually how it would read. We would take out the C after F4, and the last line before the be it further resolved would end at F4, removing the sub A in subsection 155-41.1F5. So you can discuss, but before you vote, we're gonna have a motion to amend it to read with those changes. I have another copy for you guys to look at. That's what I'm it's a more specific reference to the second definition. Discussion on the motion now. Does anybody have anything?
Everyone's good?
So what you would need is a motion to amend the resolution.
I'll make a motion that we amend the resolution.
To contain the changes that I stated.
Yes.
That the attorney
Contain the
stated.
changes.
I'll second that. All in favor? Yes.
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 So be it further resolved that based on the foregoing reasoning, the zoning board of appeals hereby affirms the CEO determination. And the secretary will file a copy of this resolution and determination with the town clerk within 5 days. I also would like to put out there a letter that we have for the town board. Let's read it for the record.
Letter to the town board. Dear Supervisor Cochran, and members of the town board, Town of Marlborough Zoning Board of Appeals, ZBA, has recently asked to interpret section 155.411F of the town zoning law and contents and an appeal from the denial of the building permit by the town's code enforcement officer. The ZBA renders its interpretation on January 8th, 2026, and a copy of that resolution is enclosed for your information. The ZBA believes its interpretation gives effect to the town board's legislative intent when it adopted its recent amendments to section 155.41.1 and 155.41.1F in particular. However, the applicant had proposed a different interpretation. We want to bring this issue to your attention so that you can consider whatever amendments to the language is needed.
Thank you.
So now you need a motion to authorize Jen, secretary, in combination with the chairman, to finalize the letter substantially in that form to send to the town clerk.
Understand? Goodness, yes. So we'll make a motion.
Someone make
I
a
make
motion?
a motion?
Second. All in favor? Yes.
Yes.
Yes. got some procedure and stuff as far as.
Gotcha, I'm gonna sit here and mark it.
Before we adjourn, Larry has a certificate he wants to read for the record.
But a certificate of completion from November 6, 2025, that I attended a 4.5-hour conference in Summerlin, climate action planning event with the Hudson Valley Regional Council. Take care of my training for